Thanks everyone for coming. My name is Rob. I organize Idea to IPO. We've been doing events in Silicon Valley for many years. We hold events multiple times a week from San Jose to San Francisco. We have a busy, busy calendar of events. I'd like to highlight just a few notable events that are coming up. So May 30th, Tuesday, at the beautiful campus of College of San Mateo, we have a panel discussion, latest innovations in autonomous vehicles. Further on down the line, July 20th, we have a fireside chat with Vinod Khosla, and that's going to be at the Palo Alto JCC. It's in collaboration with the Commonwealth Club. So mark your calendars, check all the details on those events and all our events at our website, ideatoipo.com. We were launched officially on February 1st, 2010. At that time, we had no members, no events on our calendar. At this stage, we have over 50,000 members among all our meetup groups in the Bay Area. We've completed over 1,738 events. By any standard, by any measure, we're the most active, most prolific startup event organization in Silicon Valley, bar none. I thank you for that display of sincere enthusiasm. It's highly appreciated. Our mission is to promote entrepreneurship, support entrepreneurs, build community, and provide value in the Silicon Valley startup ecosystem. To that end, we provide content that is practical, actionable, and relevant, stuff that you can actually use to succeed as entrepreneurs. We believe in building community because Silicon Valley is an aspirational ecosystem. It attracts people from all over the world who come here to do great things. In fact, I'd like to know who here is not originally from Silicon Valley? Who here was born and raised in Silicon Valley? Just you three guys? Well, anyway, welcome to Silicon Valley. So it's important for us to provide multiple channels for you to meet people, build relationships, grow your network, whether you were born and raised here or you just arrived last night. So in fact, we have a regular social event. It's a TGIF mixer, thank God it's Friday, at the Hyatt Regency Santa Clara. It's hosted by one of our team members, CJ Terrell. So let's hear it first. CJ.
Hi everyone, this is loud. Hi, I'm CJ. As Rob mentioned, we have what we call our TGF mixers. They are really cool ways to get out in the community without an agenda, just meeting people from around the Bay Area and those who are traveling through the area. We have them every couple weeks to a few weeks. Our next one is going to be tomorrow at the Hyatt Regency in Santa Clara. We have a really great crowd who always comes out. There are ways to just kind of mingle, talk by the bar, and talk about ideas to lifestyle, you name it. And we have a bunch of countries that usually come out from, you call it Africa, Europe, Asia. I've really seen it all over the course of doing these. And I do recommend coming out, namely also because they are free, great crowd. And again, they're going to be tomorrow at the Hyatt Regency in Santa Clara, which, for those of you who do not know, is by Levi's Stadium, starting at 8 p.m. Until the evening. Hope to see you there. Bye.
With regard to value, it's very important for us to provide value at each and every one of our events. So we make sure that our events are affordable, and if you cannot afford the cover charge, please let me know. We can work something out. We always need people to help us out at our events, and there are many other perks to being a team member. And at each and every one of our events, it's important that we provide a decent buffet meal. Was this meal decent tonight? Good, all right. Well, we try. More importantly, though, at each and every one of our events, it's important for us to provide value for your time, which is your most valuable resource. Anyone here getting any younger? I always need to check. But so when you invest your valuable time to come to our events, we want to make sure that you maximize your ROI. We have many partners that help us do what we do. Law firms, venture capital firms, angel investor groups, incubators, accelerators, colleges, universities, co-working spaces, lots of other players in Silicon Valley. Tonight, we're grateful to Datati Digital Marketing for hosting us at this beautiful venue. We've held many, many events here, and we look forward to many, many more. They're a great partner, and we're honored and privileged to be collaborating with them. So let's hear it for Philip, the CEO of the Toddy Digital Marketing.
Thanks, Rob. I'm Philip Goldworth. I'm the CEO here. My business partner, Roberta Kibbeth, is the president, and one of the other, well, let's see, we've been doing this now for 20-something plus years. Actually, I've been doing this for about 30 years. We help small to mid-sized companies both develop their digital marketing strategy and implement that strategy. So we're doing a lot of website development. We're doing the content for that. We're doing data sheets, brochures, other print collateral that goes on that. We have a photography and video studio here, so we also produce video content for them. We also work with larger corporations as a tactical arm to help them with their marketing efforts. And if anybody has any questions about that, I'd be happy to talk to you about that after our presenter is up. Thank you, Rob, and thanks for coming.
A few of our other partners are here tonight. I'd like to have them also come up and say a few words. Let's hear it for Ollie and Planner.ai.
Thank you, Rob. Hello, everybody. My name is Ali from Planner.ai. We make financial content interactive and conversational to help augment inbound marketing and increase conversion rate. Also, we provide consulting for anybody who's interested about chatbots, implementation of chatbot, planning on how to use chatbot in marketing, in call centers, in retail, pretty much any vertical. Please come talk to me. I'd be more than happy to talk to you and share more about what chatbots are all about. Thank you so much.
All right, next up we have John from Chamrosh. Let's hear it for John.
My name is John Gocher. I'm the CEO of Chamrosh Aviation. We're a company that builds drones for public safety members, more specifically firefighters. Our drone's extremely versatile, and it's here. So if you want to learn more about it, I look forward to speaking with as many of you as I can. We also have Jolly Ranchers, so drop by.
So though our local mission is to help entrepreneurs here in Silicon Valley, our greater mission, though, is to democratize entrepreneurship and innovation all around the world. To that end, we have a robust YouTube channel, youtube.com/idea-to-IPO. We have tons of videos. We've documented and archived many of our events. This rich, valuable content is available on demand, anytime, anywhere, totally free of charge. So whether you're in Sunnyvale, Palo Alto, Maui, Moscow, or Timbuktu. Who's been to Maui? That's it? Well, who's been to Moscow? Nobody? Well, who's been to Timbuktu? Cool. Congratulations. Anywhere in the world, and these places all have Wi-Fi, you can access the content that we produce here live in Silicon Valley. Our partner in this endeavor is one of the top professional videographers in all of Silicon Valley. Let's hear it for Tim Jeggers of Jeggers Films.
Thank you, Rob. Thank you, everybody. So I'm Tim Jeggers, Jeggers Films. I've been doing video production for a little over a decade now. I've been working with Rob on these projects and events for about a year and a half. I do a lot of corporate and keynote presentation things like this. I got my start doing weddings. I do informational interviews, almost a little bit like documentary style promotional content. And I dabble with all other kinds of multimedia and like music and photography, and just anything that allows me to be creative is, really something that I get excited about. So if you have any questions about that stuff, or have a project where you want to bring a little creativity and multimedia related things into it, I'd be more than happy to talk to you as well. And yeah, other than that, I'm gonna pass it back so we can get to the main event and bring Stan out here in just a little bit. So thank you again for having us.
Okay, so let me outline the rest of the schedule for tonight. Our featured speaker is going to come up, do a presentation. Please hold your questions until the formal Q&A session, which is going to start maybe about 50 minutes after his presentation. We'll have a microphone. We'd like people to walk up, speak into the microphone. That way we can have a clean, finished product for our YouTube video. It'll be a great resource that we can all use forever. So thank you for your cooperation. So I'd like to introduce tonight's featured speaker. He is one of the top corporate and startup attorneys in all of Silicon Valley. He is a partner at the distinguished firm of K&L Gates, and he is passionate about helping entrepreneurs succeed. Let's hear it for Stan Lewandowski.
Good evening, everyone. It's my pleasure again to be at the TADI and spend this next 90 minutes with you. So thanks to Phil and the TADI and Idea to IPO with Rob and his incredibly growing and active team. So the idea today is to give you some hints about how to build your company from day one to the day when you are meeting someone who is interested in purchasing that entity or your assets. So you've probably seen the title. The core item is how to build rather than talk to someone tomorrow. This is about a process that should start right now. And after this presentation, you will have a good idea what to do and what not to do in order to be successful later and have those very fruitful discussions with the people who will want to purchase what you've built. As you probably know, some people in the audience have seen me, have heard me speak at different events. This is what I put on my slides, that today's discussion and presentation is for educational purposes only. This should not serve as legal advice. This is not one-size-fits-all presentation that you can take and apply what I will say to your situation and be 100% certain that you are solving your problems or you are addressing the issues at hand. Just with the IRS disclosure, there shouldn't be anything in my presentation that would cause the IRS to worry about my statements that I will make, but this is what has to be there. As Rob mentioned, I'm a partner at a law firm called K&L Gates. This is a very old law firm that on the West Coast is mostly known by the Gates in its name. This is Bill Gates' father's name. Mr. Bill Gates Sr., who is in his 90s, has built the West Coast and then the Pacific and Asian offices for this firm. And then through many mergers, we now have a fully integrated law firm on 5 continents, serving very strategic locations and our clients doing business in those locations. For some clients, that presence is extremely important. For someone who is doing business just in Silicon Valley starting tomorrow, that's not as essential as for someone who's been doing this for 5-6 years, but knowing how global our operations are or are able to become, this is very important for so many of our clients, and that's why we are in all those locations. A few words about myself. As I said, I'm a partner in the corporate department. That means I work with startups and companies that are in the growth mode. Then we progress to transactions that are much more important, and that will be, to some extent, focus of today's discussion, how to get you there, which is corporate M&A, where we either buy for our clients or help clients sell their assets or companies. And then my hobby also is energy. I work with companies that develop solar assets in so many jurisdictions in the US and outside the US. Some are building, some are buying, some are disposing of those assets on a global scale. Just last thing, I've been an attorney since 2004, and during that time, I've got my number of transactions where I had people selling assets and others who were buying, so the experience goes for much more than a decade, and I will try to share as many experiences with you in the form of some stories that will illustrate some points from my presentation. Quick overview of what we are going to talk about. These are the 5 main points. You know that the title is about building and preparing for an acquisition, and you see that this is my last point, and I will spend a lot of time on it. But first, whoever has attended my 3 or 4 prior presentations knows that I like data. I'm not a data scientist. I think if I were born again, I would probably try to be one, knowing where the world is going. Then we'll talk about negotiating strategy. I will explain the M&A process so it's better understood by everyone. Then we'll spend some time talking about the term sheet, its role, why we have it, why we put certain provisions there, and then we'll prepare you for an acquisition. Again, I will lead you to that point that someone will send you that term sheet. And that's just probably where we'll end the presentation, because I want you to be ready for that moment. So let's start with the data. It took me some time, but I analyzed transactions from 2016 through May of 2017. I ended up with 1,409 transactions on the M&A space. And as you can see, most of those transactions were done in the form of a merger or an acquisition where one company was buying another. Then you see some corporate divestitures, 230, and public to private, which is so many times you hear that someone is making a tender offer for someone who is already traded on the stock exchange, and that, let's say, big private equity firm is taking the company private, just like years ago. You can remember, for example, transaction where Safeway was taken off the market, taken by a nice PE firm private, and then nicely the assets were disposed with a good gain. So this is what happened last year. Now, to give you a little bit more color, what's important? This shows you in which industries those transactions took place. So when you look at, I met some people who are in the consulting business, you can see that there is pretty much 35 big transactions in the consulting space on the B2B side. And when you have the slides, you can analyze this a little bit further just to see where your business fits, to give you a better idea what's going on. And this is only for the 10 top industries. So there are other industries where we didn't really analyze the data. Some of these names and transactions are probably well known in this room. This is, again, 2016 and 2017. The right side tells you what has happened just this month. On the left side, you can probably recognize transactions such as Time Warner Cable or LinkedIn or Tyco. These are pretty significant transactions in billions of dollars that have already closed, and we'll probably analyze a little bit more in the next 6 months. This list will become obsolete pretty quickly. Now, this is where the important part starts. And again, I analyze about 1,400, I think, and 9 companies. And the data that's mostly important to my clients is how much will I get given my revenues or my EBITDA, which is the interest before interest taxation, depreciation, amortization, in my business when companies are comparing benchmark data from other transactions and say, if this was 7x, I can probably get 7 or 8, maybe 6.5. So whatever is in blue, these deals were disclosed, but without this metric. So we only have, out of 1,400 transactions, data on 396 deals where we know what the deal size was based on the EBITDA multiple, and on average it was about 10x. So if someone had EBITDA of 10 million, you multiply this by 10, you get an idea where it was. But this is an average. So some transactions had 50x, some transactions had 4. Depends on the industry, but gives you an idea. Then on the revenue side, as you understand, on the balance sheet, you will have assets and liabilities and shareholders' equity. Then you go to income statement. and the income statement will show for a company what the revenues are. And then once you, for example, if you are selling some widgets, you will subtract the cost of goods sold, you go to gross margin, you go down, 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 you end up with EBITDA. So you know where those revenues and EBITDA points are located. That's why you always have a lower multiple for revenue, because revenue is the top number, which is much, much greater than EBITDA, right? Now, point number 2, negotiating strategy. What happens when the first term sheet arrives in your inbox? And sometimes these documents are unsolicited. Someone simply has seen you at a conference, has followed you for 6 months, and now believes that you have the 320,000 in revenue that you gathered in the last quarter. They simply believe that your product, while integrated with their bigger platform, will be a hit for them. So they say, we'll take you out now rather than later. We'll pay less for you and have you as members of the team. What I always tell my clients, if there is a chance, keep many players at bay. Once you get this unsolicited offer, see whether this really makes any sense to you and the board. Of course, you as the CEO will disclose to the board. The board will decide whether this is something viable. The board will decide yes or no. If no, then you simply put this into a trash and say, good that there's interest for what we are doing. There's some validation, but this offer of 15 million is not what we are looking for. We want 150 at some point, and it will happen. Now, sometimes I have transactions where we are dealing with investment bankers, but these are, just for your knowledge, transactions where we are really talking about things, in most cases, 100 million plus, so the company can really pay the retainer and then the success fee, being relatively happy working with those groups. In most cases, for good companies, they bring a lot of value. They can shop the deal around and bring you multiple offers. Of course, this will benefit you, benefit the providers that will work with you. There's one piece that every single document you will get, whether it's a term sheet or some proposal, letter of intent, the names are multiple. You may see something when you go home tomorrow that you received for your company, a memorandum of understanding, because someone is just looking at you and looks at the deal rather than the nomenclature used to purchase your company. I tell my clients, don't sign those things too quickly, especially when there is a no-shop provision, unless someone has no ability to continue the operations. And we have clients like that, that they know they have about 3-4 months, and they either will be sold or will be disappearing from the planet. And these are the deals where we need to move quickly, so there is not too much discussion about don't sign this or sign something. We don't talk too much about standards or not standards. We move the company forward in the best way possible for the company to realize benefit for its stockholders. So we see what can happen based on specific circumstances. As you can probably imagine, your attractiveness for, yes, no shop, that's a provision in a document, term sheet or letter of intent that will prohibit you from talking to other people, to solicit other offers. You are basically locked for maybe 60 days, sometimes a little bit more. So you are now bound to deal with this one person who wants to buy your assets or your business or your entity. Now, every single time when we talk about value, one of the first questions will be, show me the financials. I want to see whether you are generating revenue or there is simply nothing. Maybe you have a good user base and the revenues will follow. Maybe we just need to take your product and integrate this with somebody else's product already in the market with a great distribution base. Just think about some examples and you can quickly find out that there were some extraordinarily well done acquisitions in the Valley where companies with zero revenue purchased for $1 billion or more became incredible successes. And now other companies are benefiting from those great acquisitions. And there are many, many instances of that in the Valley. You can just think about Facebook, for example, and Instagram. Look at Instagram's performance over the last few years, and it's just an incredible company. Now, revenues will always help because it's easy to multiply things. It's easy to see how, by taking certain product or service into a larger platform, you can scale the business, and then multiplication is very easy to do. And this also helps when public companies have to approve an acquisition, because as you probably know, if a company is buying another company, not only the sellers, management and board and stockholders have to agree to that sale, but also the buyers. Management will discuss the issue with the board, and then it's more complicated for publicly traded companies to get things approved. There is more discussion, more investigation, more due diligence. It's always great to have great model, something that you can defend, not some smokes and mirrors that you make certain claims. It's great to take your data from the last few months and now make projections by showing nice growth will always help you. There are some people who say there is nothing better to motivate you than to show you some progress that you've made. And sometimes you don't see it, sometimes others have to see it, but by showing you that, you'll be highly motivated to do better, right? And the last piece, motivation. Motivation is great, leading you to a better result. With better results, you can tell your buyer that there is a huge revenue generation potential. This platform is simply not adequate for this. So let's become part of the bigger organization. And then if that potential can be realized, the buyer will definitely benefit. Again, Facebook, Instagram. We don't have to go too far. Excellent example. But it has to be visible. This cannot be simply puffing because people in that market at that level will not really buy those kind of stories. Even though you hear about stories where companies are purchased for top-notch dollars, and 3 years later, the whole investment is reduced in value by 50%. Happens a lot. Now, how the M&A process really looks like, so you can come to it and grab it. So in most cases, just like the gentleman asked about the no-shop agreement, you will get something from the prospective buyer. It may be a simple NDA that they are interested in some discussions, or they will send you term sheet or no-shop agreement saying, let's just engage in some preliminary discussions, but I want you to be off the market. I don't want you to get excited. Let's work this through. Don't talk to others. And again, this no-shop has its minuses, of course. Transaction structuring. Now, the main document that you will see, it's either going to be a term sheet or memo of understanding or letter of intent. This is where the main terms of the transaction will be described. And it might be a document that will have 6, 7, 8 pages for a nice merger, may have more, may have less, depends on the deal and sophistication of the people who are preparing it. I have some clients who are not necessarily using lawyers for that. They have done so many acquisitions, and in most cases, this specific client I'm thinking about is mostly giving a tiny cash boot to the seller, and about 4/5 of the consideration is always the stock of the buyer. And they've done this many times. They don't really have to have a lawyer approve this term sheet. They've done it, and they've been doing this successfully. And then you follow the chain and get to the diligence stage when the term sheet is signed, when the parties say, these are the terms on which we'll proceed with this transaction. That means now, since the term sheet says the transaction is subject to, and there is a litany of things that will say, subject to legal, financial, regulatory, and other diligence. So if those things are fine, we buy you. Otherwise, there might be problems. We don't really want to engage in that purchase because now we discovered so many things. And I will talk about some of those items and how to avoid getting to those points. So when you have that discussion, you simply say, I don't have to worry about those issues. I know what I have. And transaction documentation, again, is based on the type of a deal. If you have a reverse merger, you will have different documents than when you have an asset sale, right? Just different documents, different types of a transaction, but very similar diligence. Now we get to this term sheet. Why I sometimes spend so much time on this point? Because so many times we have transactions where people are rushing to the signature block. They are so excited that someone has put a $70 million deal on the table, and they believe that this business development person from this acquirer cannot wait until Monday. They say it's Thursday, we need to get this done by tomorrow. It's a big mistake. Very, very big mistake. Even though the money almost can be felt and you can smell it, but it's very, very far away. And when you wait, when you fix certain things, I hope this gentleman is not going to do anything to me, you will be looking at more value for yourself. And I'm speaking from experience. I had several transactions where we saved the founders several $1 million as a result of just talking to the buyer for a few more days about restructuring some of the items that the buyer put on the table and said, this is almost as good as it can get. And at the end, we probably revised 30, 40% of the term sheet and then showed the client the benefits, which of course the client didn't realize up front what they would be. Once they have that Excel in front of them, then they are very grateful. But there is always this fear that what if we push too hard, too far, and if the buyer says no? Now, if the buyer is already putting that number on the table, believe me, they are not going away. The most important part about term sheet, because if you have those transactions coming to you in the near future, you will see this. Many times, whether it's going to be your acquirer's manager or lawyer, on a call will say, you agreed to this in the term sheet. Why are we negotiating at this point? This indemnification was supposed to be XYZ, and you signed the term sheet that talked about this point. Now, the issue is almost closed. So the idea that let's deal with this later, and this is okay, we will not fix the language in the term sheet, big mistake, very big mistake. And I'm saying this only because so many people are eager to read the paper and say, it reads well. We see the number, we see what we have to do, it's a 15% escrow, 18 months reps and warranties, and I get 5 million, good deal. Let's just get this going. Think again. Different structure, of course, you've heard about companies being purchased just for equity, some for cash equity. Earnouts, very popular item. I tell my clients that this is a beautiful thing, but you have to assume that nothing will ever come. And in many cases, people end up in arbitration and litigation over those things. And we'll talk about reps and warranties, how important those things are very briefly. This is probably one of the most essential parts in an agreement besides the purchase price that will allow you then to preserve what's going to be held back, because there is almost no deal where you get all cash and consideration up front. The buyer will always, for 12, sometimes 18, sometimes even longer, keep portion of the consideration, whether it's equity, cash, or otherwise, and say, if what you said in this agreement turns out to be incorrect, if the taxes that you claim you paid, now I have an audit, I have to pay to different agencies X number of dollars. Or this former employee who you claim that it was just think of the past, now is suing us for some interesting things. We as the buyer will be on the hook for those transactions. We have to pay those people to satisfy their claims. Where are we going to take the money? From the nice escrow that you left behind and you thought that you would be getting the whole thing. Most of those escrows are a little bit touched before the money or other consideration is given back after X period of time to the sellers. To one of the gentlemen in the audience, this is the big no-shop provision. Again, you've got a deal, please do not show up around with other people. Don't accept any transaction terms from anybody else. You can solicit yourself. If you get a deal, because now someone has overheard that you are in the market, in the play, you will get a term sheet or two. You will take this document nicely and give it to your party with which you are talking and say, see, you have 17. These guys are offering 85. And the first one will say, we are going to make a good deal because you can't really get out from the deal because this piece will be then combined in the term sheet with something called non-exclusivity period, which is very similar to what we are talking about now, shopping. You can't really do anything with anybody. Please. Term sheet is just a term of the art. It is, once it's signed, yes. But every single term sheet will have a provision that will say which provisions are binding and which are not binding. So it's very essential to understand what people are signing, because in many cases you will hear people saying, it's just a term sheet and it says it's non-binding. For example, for financing transactions, most of those deals are just documents signed by two parties where there is just an intent expressed by someone to invest in a company, of course, subject to many different types of diligence, but there is no obligation whatsoever until what we call a definitive agreement is signed. So in this case, it would be a stock purchase agreement. In these deals, you may have some provisions that are binding, which is mostly the case. For example, I have transactions where I represent a little bit bigger players who will say, we are not going to spend $250,000 doing the initial diligence, and then this party simply will say, we don't really like it. So sometimes in the publicly traded companies deals, there is something what we call breakage fees, and they go into millions because the buyer simply decided that it will not proceed with the transaction. And these are very sophisticated deals, sophisticated parties dealing with those transactions, and the consequences are pretty severe. Now, if you are trying to get sold, remember about this example when I said someone is either going to survive and be acquired or is going to disappear in 3-4 months. There might be situations where you sign this document and you cannot shop around, but you need to get another $200,000 to get through this point in time when the transaction closes. You have people on the payroll, and now you calculated the money, and it appears that you have money for 6 weeks, and the deal closes in 8. So there might be a situation that you have to get some money, and that would be excluded. So you can talk to Silicon Valley Bank or somebody else and say, I need $200,000 just for 2 weeks, and you will get it back. So that would be fine. So one of the most crucial pieces for this component of the term sheet is that you limit in time the other party's ability to limit your moves. Meaning, you say, I give you the no-shop and exclusivity for this transaction, for example, 45, 60 days, depending on the transaction. Some transactions will take 6, 8, 10 months. Some we can close in 3 weeks. There's no big deal to close a $15 million deal in 3 weeks. If both parties want to do it, it's not complicated at all. It can be done. It's just the nights will be short, days long, but it can be done. Finally, your task when you are building your company is to create value from now on. If you are forming a company tomorrow, you need to create accretion, create facts that will create your stock as something that will be blossoming. So when people say accretive act, yes, your stock is worth 1 cent, 2 cents, 10 cents, and then it goes up and up and up. Now, we'll talk about those price drivers and few things that I will spend more time on because this is where the crucial points are, what you should be doing when you build your company. Knowing your stockholders, we'll talk about IP very quickly, what to do with employee company arrangements on your side to make sure that you will be liked by the buyer, and then the financials. Many companies that I deal with are in the Valley. They have licensing agreements, and one of the things that we always look at is how to structure those agreements that when it comes to a potential acquisition, we don't have too many issues to deal with. And some companies don't pay too much attention to those items. I do, because the less restrictions on how you conduct your business that you agree with the other party, the easier it will be for you to talk to a potential acquirer about the sale, because what you already have, if you are going to have a merger for your company, all these contracts will stay with your company. And the buyer may not like certain restrictions that you put over there, and then the buyer will have to go and renegotiate those contracts. So if you do your job on day one, there is no discussion. Simply the agreements will stay where they are because your company will be purchased, just the stockholders will change, and you will drive better value. Just for life sciences companies, when you talk about different fields of use of the IP, if you limit somebody's exclusive use to certain items rather than giving a broad license, you will benefit from that because you can have other licenses for different pieces that have not become part of the license with the first place, with the first party. Very often when I deal with companies that are looking for strategic financing parties, there are so many CVCs, which you probably know are corporate venture capital companies. They will come and invest $2-3 million into a company that is building something strategically important to the big company's business. They will say, we want to watch this company very closely. So we invest and you grow, we sign collaboration agreements, so we kind of monitor very closely where you are going with this university research that now has its own company. And one of the pieces that are built into the documents is the right of first refusal. This is something that will obligate you to go to your partner, strategic financing party, and every time someone sends you a term sheet and says, I'm interested in buying you, you will take this document nicely, show it to your partner number one and say, this is what I was offered. And this party will negotiate while financing you in the first place. If you are not thinking clearly and protecting yourself, you just want to get the money and then think about those items later, they will have the right, in many cases, to buy you on the terms that somebody else is offering you. Is it good or bad? In most cases, it's very bad because you just eliminated the ability for your business to shop the deal around. Say, I want to be sold. You talk to a few people, and the first term sheet comes, and you nicely have to present it to the first person. And the first person may say the first time, we are interested. So the moment you say, I'm interested in this deal, this will be your buyer. We have many clients ourselves who told us many times, if we knew that these companies that we are kind of watching had those kind of financing arrangements with our competition, we would never raise our hands and tell them that we are interested in the technology. We don't want the other big player to know that we are interested in entering that vertical. So it's, again, we don't want our plans to be known, right? By having that provision, your company eliminates many, many different points of entry from potential buyers for the future, which may end up with 50% of the value being lost in the place. This is not to say that you are unable to have nicely negotiated right of first refusal provision that makes sense for your company. But that, again, will take a week or longer to negotiate a portion of the agreement that's about 1 page long, sometimes 1.5, and people will be fighting for a week about these lines. But when the time comes 2 years later, you will see the great benefit because it will be a great return on that investment and time. drag along. Yes? Yes. This is the right of first refusal. So let's say you have a company that received investments from idea to IPO. Idea to IPO builds into its agreement provision that says every single time someone comes to you and wants to purchase your assets of your company, you will have to notify idea to IPO about that offer. And idea to IPO will have the right, if your board decides to move with that transaction on those terms, to purchase you. So that offer that comes from somebody else is simply taken by another player, and you enter into that transaction not with the person who offered to purchase you, but with somebody else with whom you have pre-existing relationship. In this case, your party that financed you, and as consideration for that financing, they just requested that this provision be added because it's just a small provision. Nobody really cares at that time what it really means. It comes a year, 2, 3 years later that people then analyze this if they've never done it before. If someone has done it before and is the CEO and gets that built into the term sheet, this is one of the main points where there will be a phone, yeah, we got this term sheet, but there is right of first refusal built into this, and we don't like it. They will never say, we like it. No, they will say, and we don't like it. Now, so you have already balancing act, right? We want the financing because we are talking about someone who is now just 1 year old. We want the money. We don't want the 3 million to go away, but we don't like this. So we usually just end up with a quick discussion and say, we will modify this. So it will reduce the pain and allow you to have more movement, but very likely will not eliminate this in its entirety because the buyer will not let you have this just disappear. But you can modify this to the extent that it makes sense for your company, and the other side will also be satisfied. But again, takes time and patience. Now, another term, drag along. This is a piece built into the financing documents that will allow the company to be sold upon approval from several different groups of people. In most cases, those documents will say the sale of the company, which will be defined, for example, a sale of the assets or transfer of more than 50% of the voting interest in the company to another person, approval by the board of directors, and then the third point, crucial point, stockholders. Now, which stockholders? Is it the majority of everybody? Is it majority of the preferred stockholders? And then a separate group of maybe the founders who are still providing services to the company. You don't want the founders who have left. This is crucial. What I say, spend again time negotiating the parameters for the drag along. Who can be the buyer? For example, could an affiliate of one of the investors purchase you? No, you exclude this, you say no. Purchases by third parties, non-affiliates of this company or any of the parties already in the company. So this is, again, when you see this in a term sheet, and you will see this first time when you do your Series seed financing or Series A for equity, these are the points that you need to put the document down. If you've never done it before, either educate yourself or talk to someone who has done it many times. Now, the biggest disaster that I've seen in the last, let's say since last March 2016, this has come up 3 times. Stock options. Yes. The main point is everything can be negotiated. And it's a matter of how nuanced that negotiation discussion will be. Because at the end of the day, once you are taught what those clauses mean and what workaround we have to make you satisfied and the other party also willing to proceed with the transaction, you will be fine. But it's a longer discussion. It's not a 5-minute talk because you will have to be educated. We'll present several different options how the tiny piece can be handled with different options on the back end, what will happen 2 years later. Then once you understand that, your team will definitely be satisfied. We just then have to somehow get the proper wording into the term sheet, because once we do that, then the financing documents, anybody can do them. So the crux is in the term sheet. If this is left in the term sheet in the wrong way, then there is no discussion later, because you will just get one response, such as, you agreed to this in the term sheet. Why did I spend the last minute talking about stock options? And there are many presentations that Idea to IPO has over every 12-month period that focus on valuation. 10, 15 years ago, this wasn't an issue. Since the Section 409A of the Internal Revenue Code was added, people started paying more attention. And if a buyer conducts diligence and discovers that there are issues with option pricing, especially when there are public companies buying smaller players, this is a huge, huge deal. What does this do? Some deals require several more weeks of what we call cleanup time. Nobody has anticipated this, of course, because the deal was supposed to close in 5 weeks. Now it's 5 weeks plus, and we are adding. Who has created this issue? The company. By doing what? First, by dealing with option grants on its own. They already done it the first time with a lawyer. Now, why would they involve anybody, right? They already know. They already see the form. They already know how to approve the option grants. And all of that is fine. The mistake is made with one component, which is the fair market value of the stock options. Because the company evolves and the stock is worth today X, that does not mean that 7 months later is also worth X. So the ultimate decision on that front belongs to the board, but the board, while approving each option grant, has to make an informed decision. And in many cases, you have board members who are very sophisticated engineers. They have not too much knowledge on the financing front. And it's very difficult then to defend that they had made an informed decision. So that's why for companies that are reaching certain stages, it's highly recommended, and I advise my clients to do that, to retain a valuation company that will provide you with a report that says your common stock is worth, as of this date, 2 cents, 7 cents, whatever the number is. But you then take this report and state in your resolution that the board has relied on this report, and that's why the option granted are at this price. Now, years ago when you were much, much younger, after the first big crash in 2002, there was a very interesting law introduced, Sarbanes-Oxley, and this is just one of the pieces about loans to board members. This is just something that when this issue comes to your attention, when you have a board member asking for a loan from your company, just talk to a lawyer and the lawyer will explain, because I see that this group doesn't necessarily have to be bothered with this at this time. So when the time comes, you will know what to do. Now, this is a very interesting point. Know your stockholders. And I say every single time when I talk about how to build companies, because when the time comes to a sale of your company, you'll be either selling assets or you'll be selling equity in the company. Through a merger, the buyer will come and use an acquisition subsidiary that will then merge with your company will survive, you will receive consideration for your shares from the parent, boom, you are out. Now, who are the stockholders, right? So some companies are bought at the early stage. There is 15 stockholders and nothing. There was never any financing. The company got bootstrapped, got 600,000 in convertible debt, never got Series C, never got Series A. No one has ever performed any due diligence on a scale that you would really want to see. And now the company is being bought. And the founders are running around saying, we've done all of this with our internal resources. Now they get this nice lease that says diligence lease. We want all these materials from you. They say, we don't really know whether Catherine is really a stockholder now because she was supposed to pay. We don't really have any record that she paid. And the issues are created. Or sometimes you will have a transaction that happened to me. I got a term sheet, got a client who came and said, listen, we got this $20 million deal. I'm the sole owner of this entity. I said, that will be easy then. As it turned out, before we got to the closing, there was one guy who claimed that he's also a co-owner of this enterprise. So you can imagine how now going, in that case, the deal closed 2010. We were dealing with a company that started in 2000. So I wasn't even a lawyer at the time when they dealt with those things. The company had many stockholders. But over time, people lost faith in that entity, and the main owner was simply accumulating shares from everybody and simply said, I think I'm now the sole owner. It happened that he missed one who got the documents but never signed, never got paid, and it wasn't a deal that the main guy expected. Stock option plan, I always say, have this as your currency, but it has to be adopted in accordance with corporate and securities laws. Then you can hire anybody you want, pay them with paper, and successfully build your company, because that's an incredible asset in Silicon Valley. People understand what options are, but it's on you to issue them in compliance with all the laws that not only now you are happy that you have developers working for paper, but when the time comes to go to the confession, to the buyer and explain what you did, you can always say, I don't have to worry, I have it done. Again, very quickly, every single stock that your company issues has to be approved by the board of directors. If you have a company that hasn't done it, you go back and fix this. So you have agreements, you file securities filings, and keep either your Excel file with everybody listed as a stockholder, and make sure that you go back and check every single person's who appears to be a stockholder consideration for the stock they presumably purchased. If you can't find an agreement, then you have to create one. And then you have to go back and say, I can say for each of these transactions that this person paid cash, this person contributed some services, this person has done XYZ. Every single box has to be checked. And when you do this now, when you have some free time, you will save so much time later, because you will be panicking and you only have limited time. Upon request to open your data room, you will have to do this rather quickly versus I will do this next week when I find my records. That answer will not fly well. Okay, on the IP side, inventory all your assets, and one of the things that companies don't pay too much attention to is trademarks and brand names. So many companies don't really understand what the difference is between brand name, domain name. Oh, I have my name, I now have different domain. Those transactions are very, very cheap to do. And that's filings with USPTO for the trademark protection. Those things are cheap now, but will be so valuable later. It's the value of your company, the goodwill, that once you say, it's the Tati, this the Tati, and people know what it is, rather than some other company claiming we are also doing XYZ things, and now there is a confusion in the market, right? Because you don't want to have a stack of demand letters and someone claiming that you have to resolve this, otherwise you will have a big problem. Employees, very quickly on that front, you want to have your contracts with your employees and people who have purchased shares from the company with some acceleration components that we call double triggers, meaning if a buyer comes and buys your employees, because at the end of the day, in many transactions, we say one company bought another one, but it's actually the talent that's sitting under this nice cover called a company. The buyer comes and says, these 8 people are so crucial, we need to get them. But of course, in order to get them, we have to pay them for their company. And then we get them as so-called key employees. We have them, and then you see double trigger, meaning you have a transaction that says these people will have acceleration of their stock if they get fired after 12 months. In many cases, this doesn't really happen. One point on this issue, for many companies, when they are in trouble at a certain point, they will be selling more and more equity, giving liquidation to many, many players. And then at some point, someone will wake up and say, excuse me, but when we look at the liquidation stock, there's not too much left for the management when we get this company to the sale point. So we have to do something for these guys to be motivated, right? So sometimes we build what we call carve-outs, that certain percentage of the consideration in an acquisition will be just given to the management. So we keep them motivated to build a company and not to go somewhere else. Just financial situation, just have someone from day one, small bookkeeper, someone who understands what they are doing. When you grow, you switch to another one who does more sophisticated things, but have someone who can trace the life of the company to day one. So when you prepare the financials, you understand what they are. Someone will audit them. And again, reputation will be essential in so many of those discussions that the financing parties will have. And a quick recap. So we talk about negotiating strategy. I think you understand the M&A process, how this looks like from a big 30,000-foot overview. You know what the term sheet is and what should be in that document, how you should treat that instrument, and how to prepare for an acquisition. Again, we had 50 minutes, not 50 hours. But I encourage you to ask as many questions as you would like. And this is your time. So any question is a good question. And don't be shy.
First of all, let's hear it for Stan.
Thank you so much.
We would like to take as many questions as possible, so please kindly walk up to the mic right here. Speak into the mic, introduce yourself, go for it.
I'm Chase. I'm the COO of Shamrock Aviation. And I guess my question is just, what is the biggest mistake you've seen startups make in the acquisition process?
In the acquisition process, it's just one place where you as a founder can make mistakes, and that's the term sheet stage. If you think that you can handle that component yourself, and then you understand that you have to have someone draft the documents and negotiate them, and then you go to them with that signed document, that's the biggest mistakes you've made. And I mentioned this before because they are transactions assuming you sell your company for $80 million in 3 years' time. It may happen that you will lose 3, 4, 5 million, depending on what the capitalization structure looks like, if you just make a few mistakes in that process. And it's a long discussion what. There are many examples and people who have done it. Now they are, let's say, disadvantaged by those deals, but there was no escape after the deals were signed. And the other party will always say, you signed this term sheet. There's no excuse to say, oh, I didn't know. That just shows bad judgment, right? So be someone who is patient and prudent when the time comes to take a little bit more time. And at that stage, it's not about the money because you are already extremely valuable. So it's not that you are saving a few $1,000s. It's just about really understanding how the process works and how much benefit you can derive from doing this with the right people.
Thank you.
You're welcome.
Thank you for the great presentation. If I understood correctly, in one of the bullets in one of the last slides, you mentioned that in order to keep the managers motivated, make sure to give them some amount. You had mentioned 10%, I assume it's an example. Now, 10% of the proceeds. There are shareholders in the company. when you decide that you pay this much 10%, for instance, of the proceeds as to keep them motivated, these 10% is part of the, has it been counted into like the portion of the shares that they have? Or no, the shares that they have is separate, this 10% that comes is separate, kind of like a bonus.
Yes, there is one point that everybody has to remember when you do financings. You as the founder, you will have common stock. And then when the company goes through several stages of financing, the company will be issuing what we call preferred stock, different series of preferred stock. All these shares of preferred stock will have senior liquidation preference to the shares that you as a common stockholder have. And in this specific transaction, if you apply the waterfall provision and just give everybody who has shares and will be getting distributions in accordance with the rights that those shares have, it's possible that when you get to common stockholders, there will not be anything to be given to those people because the liquidation preference stacked with Series C, B, and A might be $50 million, and now the acquisition is for 30. So not only the common stockholders will only get 0, the preferred people who claim that they would like to get at least 1x back, the money back, they are not getting what they invested. So if you already know the company is in big trouble with the last round of financing, you build a separate agreement that the board has to approve and say, when there is an acquisition and we look at the liquidation preference, 10% of the proceeds from that transaction, the 50 million, the 5 million would go in that case to the management because they allow the company to even get to the $50 million mark. Without them, if they just said, excuse me, but I'm done, and the 3 big managers left, the company could be worth 0. So the preference people will say, yes, we agree that they will get a piece because without them, we get 0. So that's the motivator for the main team to continue the belief in business. And if they do, then everybody benefits. Otherwise, everybody gets simply 0.
If I may have another question.
Yes.
Does this mean that preferred stocks, the preferred stockholders are more equal than the rest?
They are always first. And it's a matter whether they are what we call pari passu among themselves. So let's say you have Series A, B, and C. And of course, we operate with letters starting with A. So the C people would come last. And if the company is already in trouble, they will invest possibly doing what we call down round, meaning it will be investment at a valuation that's lower than the last valuation that the deal closed for Series B. And then they will position themselves at the top of the list of the people who will be getting proceeds from any what we call liquidation event, whether it's a merger, asset sale. So they say, we are coming as saviors. We are giving you 10 million. We will be first ones to receive 10 million when the money comes. And then we see what happens next. So they may say, okay, B and A will be treated the same way. So if only 60% now is available in proceeds, they would get 60% of the investment later. So it's very important where you are in the hierarchy because when the company is sold for, let's say, 200 million and the liquidation pref for the preferred is only 50 million, then everybody is happy because the preferred will get money, common will get money, but what happens when there is not enough, right? So it's not that we have only transactions where we give money to everyone. We have transactions where only sometimes the first group of preferred investors get something and the rest get 0.
Thanks.
You're welcome.
Hi, thank you very much for the presentation. Can you talk about some of the methods that are used for valuation? How do they determine the value of a company for M&A?
Yes. So in most cases, what happens, if you have a deal, let's say 30, 40 million, in consideration, there will be some financial advisor. There might be a small investment boutique firm, and when you get a term sheet, the term sheet may come to you on its own, but in many cases with some of my clients, we have hired people when we tell them, listen, we are at the point that we want to find a buyer. And we are looking at between 100 and 120 million in consideration. Simply find us someone. And there's many companies that we call investment boutiques. They go out and have great network of big companies. They say, okay, I will go to Cisco, I will go to XYZ companies that will then present their view on what I'm presenting them with, and probably I will come back with something that makes sense. So Cisco may say, okay, how much do you think these guys would want? And the discussion really shifts to benchmarks and comparables. They say, okay, this is this vertical. How many deals have we done in this space? What were the multiples? Okay, we did 14x for one of the parameters that we discussed. Okay, what did we do for this one? And then you compare and use the numbers that make sense, or you go with big acquisitions that go in millions because you want someone who is so essential to your business and to your growth that you say, we want this person first rather than giving someone else a chance to acquire that person. So it's, in most cases, you will have financial advisors who will be trying to work for you and derive the best value possible because you will benefit from that deal, and also they will do the same because of the success fee on the back end. You're welcome.
Thank you for your presentation. It was very instructive. My question is, we all know that lawyers and companies like that are very expensive. And a startup, I'm a startup CEO. So a startup, and it's not first time. A startup has to pass a lot of things like making the business plan, meeting with a lot of people, getting some associates, and eventually getting that dream term sheet, millions or zillions. Good. The problem is that in order to pay your lawyers, you need money. And in order to get that money, you already get involved with, at least with some angels or at least with some called advisors, and you already have some agreement with that advisors in order to get the money. You cannot go to lawyers before you have the money, and by the time when you get the money, by the time when you go to lawyers, you are already tied. So what do you recommend in this situation in order to make everybody happy and to don't do that mistake you are saying that sign agreement before you consult your lawyer?
And I will repeat that don't sign agreements you don't understand without a lawyer. That's the primary thing. And we are lawyers and we understand legal issues, but we are not doctors, so I will not try to cure my heart disease myself because I'm not competent enough to do that, right? So that's why we do that with the use of other people, and to that extent, lawyer versus lawyer is just like cardiologist versus dermatologist, right? So proper lawyers for proper things. What I encourage people to do is to talk to a lawyer on day one when you want to start a company, not when you form it, before you even start it. Talk about terms that will work for your case. Have a nice presentation. Say, Mr. So-and-so, I met you over there. May I meet with you for 30 minutes, 45 minutes, doesn't matter. I will come, I will bring my 1 or 2 page executive summary. I will bring some slides. I will show you maybe a demo that I did in my free time. Tell me what you think and how we could work together. And this is my plan for this entity. I want to do XYZ things in the next 6 months. How can you help me? How can we work together? And believe me, there won't be a day ending without you going home with a secured relationship. Someone will say, yes, this is good enough. We'll work together. And this will be a competent lawyer. It's a matter of really spending the time talking to right people. And everybody understands how difficult it is to start business when you have immediately expenses and you are cutting corners because in most cases you are leaving your current employer, so you have less revenue, you have to sustain your operations at home and at the office, and it can be done. It's a matter of really discussing this and having your case built in a way that you can attract attention to what you are doing. And if the first one says, sorry, I'm not interested, it's very likely that the third one the same day will say, I'm interested. The same will happen later with investors. You will knock on a few doors, you will go to the first 5, 6, they will give you good feedback, that will benefit you, you will improve your presentation, you will go to the 8, and the 8 will say, I like what you are saying, but when you record yourself and compare the 8 speech with the first one, you'll be talking about 2 completely different companies.
Is your company, Kellegate, offering this kind of services before starting the company?
We work with different people, different companies, and we have what I call happy relations. It's a matter of having 2 people have their minds meet at certain point, and everything can be done. It's a matter of discussion more often in a private setting than in a public one, because nobody wants to disclose too much about what you are doing and how you are doing, what your plans are, what's the secret sauce is. And once we know that, we always offer things that make sense for you and us.
So if I send to you an email with my idea, for example, my plan, should I come half an hour to your office and...
That would be desirable. I would rather have a discussion than email exchanges, because that just wastes so much time. Meeting would be much, much better.
Thank you,
You're welcome.
Thank you.
Hello, and thank you for your presentation. So the question is, how many acquisition and merger has happened in the US in the past year, and what was the trend since 2000?
I started with this nice pie over there. So we look at data from a leading provider of this data, which was identified on those slides. And just one thing about the slides, they will be available online probably within the next 7 days. And if you are interested in getting them sooner, just send me an email. I will send them to you tomorrow. That's what I've done. Nobody has claimed that it took me more than 24 hours from the email you sent. So the trend, I didn't see in the last year any significant changes in the multiples, because they were pretty much general. You see some outlier situations where companies are just coming and paying huge premium because they want to acquire someone with an asset that's so valuable. You look at LinkedIn's acquisition. Why was Microsoft after LinkedIn? One thing, it's a big, big set of data that now is in Microsoft's hands. Second one, there were already other players just waiting and knocking on the door. And what I can see as a trend, just last week I attended Applied AI conference in San Francisco. Great event, hundreds of people, and people talked about trends in the AI space. I see that there will be more and more AI-focused acquisitions in the next, not necessarily months, but 2-3 years. You will see more and more noise given to those deals rather than, oh, some cybersecurity firm is being acquired. This is kind of things of the past to some extent, passé. Those new technologies will definitely drive better valuations, because just think about what Uber, Lyft, Ford, Waymo, Google, all those entities that may have different names are doing in this space, for example, self-driving cars. Nobody knows really how this industry will develop, how it will end up in 5-6 years' time. Ford, if asked what the future will look like, can't really tell you, but everybody wants to be in the game. Ford, as you probably know, made a very, very big acquisition of a company that you see in San Francisco. Someone has heard about Chariot, for example? Okay. Simple thing, over $1 billion acquisition value, things that you would have no idea why, but you put the puzzles together and you see a trend that companies are investing in the future in things that are just, in many cases, pretty foggy, just like the autonomous cars, self-driving cars. It's foggy. We know that companies are working on it, but how at the end this whole industry will look like, how the laws will be adopted to the situation, nobody knows. People have some thoughts, and it will be evolving month by month. At the end of the day, those who are leaders today, they will own huge market, because maybe in 10 years' time, you will just press a button on your phone something will arrive at your doorsteps, take you to your office. You will exit that car or whatever that will be. You will go to the office. 10 minutes before you will think about going home, you will press that button again. A car will arrive, take you home, and you will see definitely change in the car ownership, how people travel, how we approach different things. I think it's compared to when we were young, and by young I mean, let's say 40 years ago, we live in very, very amazing times. Just when I look back, I just say my life has changed from like 95 up. This is where I see the change in my life. Early 80s, late 80s, 90s, until the internet really was available, I think the world was pretty boring to some extent from the technology perspective, even though people would tell you that, hey, so you miss Atari, Commodore 64, and other things. This was also amazing time, but I think that we are lucky and blessed to some extent to be living in this era because it's just incredible how things are changing. And I'm saying this from the heart of the innovation on a global scale. People are coming to this valley from where? Everywhere. The smartest people, whether they are from one country in Asia, one in Europe, South or North America, doesn't matter. This is a magnet that brings the brightest and the best. And the whole humanity and the world will benefit from this. So we just like Rob asked at the beginning, we should be very, very grateful for where we are because this is an incredible place and we are just first witnesses to what's happening, even though people have access to information wherever they are. But we see this by walking on the street. And it's fascinating. So you will see trends. The more innovation there is, the more value there will be put on those companies. Because whoever can see the things that you and I cannot see, those things behind the fog, that will be seen clearly 5 years from today, whoever sees them today and creates a market for those things, these are the winners.
Cool, thank you.
Welcome.
I'm interested to hearing your thoughts about cross-border acquisitions. If you can just let us know what are the major differences between acquisition of an American company by an American company versus acquisition of European, let's say, company or company based anywhere in the world by a United States company, and vice versa, acquisition of an American company by the company located elsewhere. If you know, maybe like what are the major pitfalls?
The most deals that I do for my clients is when my American clients want to expand to certain jurisdictions or regions. Just in a global setting, someone says we need to take the Western Europe as our market. You look for acquisition targets that already are based in those jurisdictions, and then you acquire them just like you would like to buy a US partner for your expansion in the US. You go and negotiate with one or more parties, depending who the owners are. And the acquisition is a little bit more complicated because you need to involve.
So which country law system is being used for an acquisition?
We try to use either the US law or UK law, depending where we go. If we go to Europe, and again, this is one of the things that will be negotiated, heavily negotiated at the term sheet stage. I try to put New York law for those kind of acquisitions. Sometimes we end up with English law, not UK, but English law. In most transactions, people in the US will try to push what I call domestic law as the governing law because you don't necessarily want to go to another country or be in New York and interpret with some arbitrators laws of England or France or some other jurisdiction. And a lot of time is spent on diligence because certain things are done, for example, for companies that are operating solely in Europe. They operate under European law and guidelines. And then when we buy them now, there are hosts of issues whether, for example, US employment law applies to people who are in Ukraine or Poland or Belgium or other places, because that's now a more complicated thing. And we address all of those items, but they are very important, more costly than the domestic issues. And at the end of the day, everybody is happy. Just the understanding of those transactions, I think, is, for us, it's especially with people, I think, who come from different jurisdictions, who have traveled the world a little bit, and feel that now they can really touch the globe and say, okay, I've been in this 5, 6 things, that's actually the globe. It's not just that you were born in one place and now you live 10 miles from your mom the whole life. I think it also helps us to navigate through those other systems. We feel much, much more connected, I think, especially with me, with the Europeans deals. I feel that I'm just dealing with another so-called domestic market, whether they are French, Belgian, or Poles, or Ukrainians, doesn't really matter.
Thank you. So
Welcome.
one more quick question. So when you negotiate which country's law system will be used, is it always one or the other, or is there anything like international law where you can combine some of the like United States principles and some of the principles of the European country or country somewhere else?
No, this is not, we don't want to create some issues for ourselves. So there is one law that governs the transaction. The only international aspect that really is seen very often will put arbitration, for example, mediation arbitration that will be governed by the rules established by the International Chamber of Commerce. So people feel more comfortable that if there is a dispute, they don't necessarily have to go to state of New York and New York City to deal with the dispute. We give the parties some time to settle the issue in an amicable way. If they can't, then we mediate in some cases. In some, we just go straight to arbitration because you don't want to end up with some system and a judge for 2 years and deal where, for example, the issue is about breach of representations that gives someone the right to keep a big chunk of consideration that founders are waiting to get and build something else or buy homes or do whatever they want to do. So we choose systems and means that are pretty fast compared to the alternative.
Thank you.
Thank you for an interesting talk. You've been talking tonight about setting up companies, looking to the future, and getting acquired. I'd like to ask a question about Silicon Valley. Companies get started, provisional patents get filed, people get into disagreements, the company dies for a while, people disappear, one person keeps it going, company gets reformed, and finally it looks like it's got a chance of doing something. But you can't find the other people anymore. You have no idea where they are. Should you just bury everything and start anew? But how can you start anew with the same IP if those people, are they going to show up out of the graveyard?
I will address this very quickly. There is no other way. If there is some valuable IP, the first question would be, why has it been abandoned by everybody so nobody pays too much attention to what's going on? But if you want to continue with that business, you really have to go back to the foundation and start looking at the first brick, get to the first floor, clean it up, and once you clean it up, then you will be able to have solid discussions. Otherwise, nobody will really want to talk to you for too long about an acquisition because nobody will be buying an entity from people who are partially the owners of an entity, right? If someone wants to buy you, they want to buy the entity and be certain that this is the entity they bought and it's theirs versus yours today and 15 other people who are somewhere with some claims. This is not really viable, right? So you either fix this or find a way for a majority of the board and stockholders get together and approve maybe an asset sale, so you create another company and possibly buy the assets from this interesting gizmo and then the gizmo doesn't really interest you. But again, this is not very easy, not as straightforward as I described, because there could be claims of fraudulent conveyances and other things. It's basically, things can be done. It's a matter of how much time you have, how much money you want to spend, and whether this will be done the right way. I prefer the right way, and sometimes when people hear that it will take X many weeks and the list of things that you then have to deal with, that I review the document, say, these are the items you have to really fix, that could be something that you will just say, you know what, I'm giving up. I don't want it. And it's a matter of cost-benefit analysis, right? If the company could be sold for $200,000 after everything is done, don't waste your time. If you are talking about potentially maybe getting 5 million, that's a different discussion, right? But in most cases, these are still companies that are not extremely valuable. Otherwise, people would be cleaning up much, much faster.
Thank you.
You're welcome.
We have time for one last question, and I think it's going to be a good one. Right?
Hello, I'm Carol from France. I would like to know, because you talk a lot about the KPI, could you describe about the team, what you are looking for?
If we are talking about the management team, if this is the main thing, many of my financing parties, for example, are looking for companies with at least two founders, two people who can do two separate things, and they should be doing as many interesting things for the business as possible. Many of my guys will say that they are not interested in teams that have ideas, and there is 5 of them, and they will then seek financing to then use the financier's money to hire someone who can really code or build a prototype or something else. So most of my clients, when I have the initial discussions, I simply say, okay, which one of the 2 or 3 of you is building the prototype? Who is coding? Who is doing the core things? If they say, oh, well, I'll just look for that person. So the next question is, so what are you doing in this office now? What is this? Idea, exposition, or something? It's something that will not be viable. The more skills, knowledge, experience is with 1 or 2 people, the initial 1 or 2 founders, the better chance for the company there will be that you get funded quickly, rather than begging for 2 months and running through the valley and saying, I have 200,000 that I can't raise for 3 months. People who can present, who have achieved something, or even if they were VP of product at some company for 5-6 years, they understand how to build certain market for now the product they build for their own company. If they can sell this, sometimes it takes them 3-4 days, and this is now autopsy live examples. They can end up with $1.5–2 million the first week and say, okay, now we are set, now we need to really build. So they raise even before they have the whole team. They say, this is the guy 1, this is guy 2, we get the money, we are building, and they have an excellent plan for execution. So they get the funds, 2 months later they have excellent website, and boom, contracts follow, because California has this great thing that something called non-compete agreements are unenforceable. So you see sometimes big companies, extremely successful, even on the New York Stock Exchange, suddenly the top management disappears, and 3 months later they are building a startup that will be doing almost exactly the same thing that the company that they left is now doing. And they incredibly quickly gather financing on valuations that will blow people's minds. But those things are happening. So again, team should be as best as possible, because you may survey people in the valley who are investing and say, what's the most important for you, team or product? And you will not find anybody prudent saying the product. They will say team, 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 team.
Thank you.
Welcome.
Let's give it up for Stan.
Thank you so much.
So if you'd like the slides, please email Stan directly. The video will be available on our YouTube channel in a few weeks, youtube.com/ideaIPO. Stan will stick around, take some questions one-on-one. Feel free to network, socialize, connect, take some food home. Thanks for coming. See you next time.